Hello out there, legal warriors. How long does a no contact order last? And I'm talking about a no contact order in Washington State. I've been getting that question a lot lately. There's been a lot of confusion, especially on criminal pretrial no contact orders. So in this video, I'm going to cover how long you can expect a no contact order to last, what are the factors that control that, and go over a few different things that you need to know. So if you're interested in this area of the law or this applies to you directly, stay tuned because this is the video for you. My name is Attorney Lance Fryrear, and I've been defending people charged with crimes in Washington State for more than 20 years. I've been putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people will get the help they need. And I'm just going to jump right into it. A no contact order. What is it? Well, a no contact order, in this case, I'm mainly talking about where a criminal court has a charge against somebody, typically a domestic violence charge of some type, and they order that defendant to have no contact with whoever the alleged victim is, sometimes even other family members, children, and it's a pretty traumatic experience. And there's also no contact orders which are called protection orders or restraining orders in civil matters, and I'm going to talk about those as well. But for that criminal no contact order, how long is it going to last? Well, here's where the confusion comes in. And I think I've gotten this question in my practice maybe 3 times in the last week even, because it's pretty shocking. So as a defendant, you go to your arraignment, and an arraignment is where you enter a plea of not guilty. And maybe it happened in jail, and maybe it happened when a defendant is out of jail. But almost always the court is going to issue a pretrial no contact order. What a pretrial no contact order means, it's an order that's issued as a temporary order while the case is being decided. Even though the defendant is presumed innocent, which I have my own debate about whether or not defendants are really presumed innocent, but even though a defendant is presumed innocent, the court is allowed to set conditions on the defendant at the arraignment, including that pretrial no contact order. And so years ago, what would happen is the court might issue the pretrial no contact order, and it has to have an expiration date, and they might put the expiration date for 6 months out or a year out, things like that. And why it needs an expiration date is because it gets sent to the law enforcement people who enter it into their computer, and the computer wants to know how long does this order last for, that keeps the defendant from contacting whoever the protected party is. Well, what would happen in the past is that a case might take, let's say they issued a 6-month order to begin with, and what if the case took 7, 8, or 9 months to conclude? Well, in real life, what would happen is during these pretrial hearings that would go on, the case would go on for 6 months or 7 months, and then the court and the prosecutor would forget that, hey, that pretrial no contact order has expired. And it's not like the defense is going to stand up and say, hey, extend that order against me. You know, that's not what the defense is going to do. And so what was happening in certain cases is that an order would expire, and even though the court intended protection to exist, it no longer existed. And how overworked the prosecutor is and how overworked the whole system is, things would slip through the cracks. So nowadays, what you see more often than not is the court issues a no contact order to arraignment, and they hand it to the defendant, and the defendant leaves, walks out and looks at the order, and it's like, my God, it says 5 years. I can't see my wife or my husband or my children or whoever for 5 years. Are you kidding me? And then, of course, it's stress and anxiety, and they totally freak out. And that's because the court doesn't explain it. Nobody explains anything in the criminal system for the most part. That's why I'm doing these videos. So even though that order that is issued will have an expiration date 5 years in the future, and believe it or not, some of them say the default is 5 years if no other date is issued, don't expect it to last 5 years. It's a pretrial no contact order. And I feel pretty comfortable saying in the large majority of cases, if they're handled correctly, that at the time of resolution, it's highly likely that that pretrial no contact order will get removed, or if it gets reissued, oftentimes it will be for a lesser amount of time, but plan on it if you do the right things, that it's only going to last as long as the case lasts, is what the hope is and what the expectation is. It's not necessarily what will happen, but that's what we would hope for. So is it going to last 5 years on a pretrial no contact order? No, only if it takes 5 years to resolve your case, right? And so it's an important thing to remember. Can a no contact order be terminated prior to resolution of the case? Well, maybe. And I have a couple different videos on this channel about that, and I'll just go into it briefly here. If a protected party, an alleged victim, wishes to either modify or terminate a no contact order, they can ask the court for a hearing to do so. It's totally different process in each court. Criminal courts and criminal law is very, very local to each court does it differently. But for the most part, they're going to talk to a victim's advocate who's going to let them know how they can request the court to have a hearing. And more often than not, the alleged victim needs to write out why he or she wants the order terminated or modified, and then typically there'll be a court date set for the alleged victim to appear, and more often than not for the defendant and the defense attorney to appear. And at that hearing, the most important thing, I think, is time. The court, when the case is newer, the court is very afraid about dropping an order, modifying an order, because everybody's self-interested. That court wants to protect him or herself from making a mistake, and the stated reason is they want to protect the alleged victim from anything happening to them. So the most important thing is, if it's really new, it's a month or two old, the court's probably not going to do anything. If the case is older, it's more likely the court may do something. The second most important thing, they're probably like 1A and 1B, is what is different today than the day when the court issued the order. Today being the day that the court's being asked to drop the order, okay? So that usually means they look at the defendant and say, hey, what have you done, defendant? Although you're presumed innocent, what type of education have you done to correct your innocence? Or, I'm being a little sarcastic, 30 years in doing this. So for the most part, the defendant may have done an anger management class or domestic violence moral recognition therapy, DVMRT, or they may have done some alcohol treatment. They may have done personal counseling, but the defense will either show that they've done something or not show that they've done something. But if they've done something and the case is older and the alleged victim sounds strong and not being manipulated, then there's a better chance that the court may terminate that order early. So a pretrial no contact order in a criminal matter says 5 years, won't be 5 years typically, might be able to be removed early. But oftentimes you're thinking about, at resolution. And if the resolution's really quick, if the resolution happens in a month or two, it's also less likely the court's going to drop it at resolution, because, again, the most important thing is time and how it affects the psychology of the judge's brain. Okay? So that's the criminal side. On civil protection orders, it's a little more simple. A temporary protection order, if you've been served with one, you're going to see it's good for 2 weeks, and you'll probably get it less than 2 weeks before the hearing date. If a permanent order is issued in a civil restraining order hearing, domestic violence restraining orders, stalking, harassment, those type of things, the default in the court's mind is 1 year. The default is typically a year, and there's going to be a date listed right on the order, okay? In some very extreme cases, they choose to issue more than 1 year, and they are empowered to make it last forever. And if it's just a 1 year order, when it expires, are we done? Well, it depends. The protected party has the right under most of the statutes to go in before the expiration and ask for a renewal. So even though it's 1 year, it may not go on forever. So it may go on for longer. So if you've got one of those orders against you, it's really important that, number one, you contact an attorney to see if there's anything you should do. But and then two is really, really be careful not to have any more problems. And if it's if an attorney may tell you, if an attorney looks at it, they may tell you maybe you should do a couple things, a class or two, if it's a DV order, to have you a better chance of fighting a renewal should the petitioner seek to renew the order later. So I just wanted to really make this video because of all the confusion, and I hope you found it useful. If so, please like and please subscribe, and more people will get the help they need. And more importantly, if you have this type of situation, if you're charged with a crime, if you get a question about an order, if you just need some help, feel free to give my office a call. My name is Lance Fryrear. My firm's been defending people charged with crimes all throughout Washington State for more than 20 years. And if you give us a call, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.